for our nation and for the people we represent here in New York. And I would say with respect to the Dobbs decision, it was the biggest setback for women's rights in modern history. So what we had to do is adapt to the circumstances, recognize there's a lot of fear and anxiety, and it was palpable. I was out in subway stops and farmers markets and just people coming up to me, women coming up to young women, literally just throwing their arms around my neck and just some of them sobbing. It was very hard for people to anticipate a post-Roe world, despite the fact that in New York we feel protected, but there's always that underlying anxiety. But what if Washington does something else? What if there's a change in leadership in our nation's capital? So they're scared. They're scared. And they're looking to us for leaders and for leadership. And I want to thank everyone who stepped up, my partners in state government, extraordinary. The work that they did, Speaker Carl Heastie, Majority Leader Andrea Stewart-Cousins of the Senate, coming together to help us fight back. And so we knew what we had to do. We had already called an extraordinary session, and they literally are called extraordinary sessions, to deal with the cessation of our right to deal with concealed carry guns the way we choose to after 100 years. I'll talk about that in a minute. But as part of our fighting back to protect women's reproductive freedoms here in the state of New York, at 2 a.m. I issued a proclamation to say that in this extraordinary session we'll not only deal with the issue of making changes in our law to deal with the concealed carry decision last week, but also to allow for there to be an amendment to our state constitution to protect the rights that we hold dear in the state, the right to reproductive freedom. The Equality Amendment, which Senator Liz Krueger has been a champion for years and years and years, finally received word at 2 a.m. that there had been a conceptual agreement between the two houses, and that's when we took the action to allow the consideration of this during this time frame that we have before us, which was late last night today, and it's being worked on now. And that basically permits discrimination on a number of, number of reasons, including pregnancy and pregnancy outcomes. And so that is going to protect reproductive health in the state of New York for generations to come, and we'll continue with the legislature to get over the finish line, which we expect hopefully in the next few hours. I know the Senate had been working hard, wrapping things up, and now the Assembly is in session. So, dealing with that, middle of the night, made the adjustment. Good news. Happy to wrap that one up. But also, the purpose we gathered after I heard the Supreme Court decision last Thursday. Seems like an eternity ago. We heard that, and I said, I will bring back this session. I will get the legislature back, and we'll start up again, and to adapt and make the changes necessary after the Supreme Court overturned our concealed carry law. Again, on the books in the state, working well, working successfully for over 100 years. And because with the stroke of a pen, they removed long-standing limitations that we were able to use in the state of New York to make smart decisions on who should have the right to carry a weapon. Literally, concealed carry means a hidden weapon. And so we believe that gun laws like those have made New York State safer and has made us the fifth lowest, we're the lowest, fifth, I'm going to get this right, fifth lowest state in the nation in terms of firearm-related deaths. Okay, reminder, there's 50 states. New York State, with our sensible gun safety laws, including the concealed carry law we had on the books for 100 years, had us as the fifth lowest in the nation in terms of firearm-related deaths. So the CDC national data shows that there's far fewer people killed in states like New York where we have strong gun laws. Compared to other states that have very limited, if any, restrictions at all on who can receive guns, background checks, concealed carry opportunities, New York State has a small number, 5 per 100,000 of deaths from firearms. Now, how does that compare with other states? Mississippi has 28.6 deaths per 100,000, Louisiana 26 per 100,000, Wyoming 20, I can go on and on. So those are the states that have minimal gun safety restrictions, minimal compared to us, and what has happened? The whole argument that the more people who have weapons will stop the bad guys with a gun because the good guy has a gun. You've heard this argument. It doesn't work. The data shows that that is a false argument. We have the statistics that show that. Because the takeaway we get from those data is that you're 4 or 5 times more likely to be killed by guns in those states than you are in the state of New York. And there's another important statistic that I want to share with you. And this is the one about states that perform their own background check, something I'll be talking about as part of our new law when it's passed. States that perform their own background checks. Now, right now, the federal government has their own backgrounds, point of contact, point of sale. You want to purchase a pistol, for example, you have to go through a very quick background check at the point of sale. So the states that actually are doing it on their own, and I believe there's 13 states that do it on their own, instead of relying just on the federal database, and what does this give you access to? When states do it on their own, they have a 27% reduction in firearm suicides and a 22% reduction in overall homicides. So what's clear is there's also an opportunity for states that are serious about protecting their citizens, like New York, where we can say, we should be able to take this over. We don't need the feds to do the work. We will do it here in the state of New York, where we can have access to our state database as well as the federal database. So I just want to demonstrate, again, through statistics, because the data will tell the story. We're talking about the need for more common sense gun safety measures, not fewer. Because think about this scenario in light of what the Supreme Court decision just did. Imagine you're on a crowded subway and you bang into somebody inadvertently. Tempers flare, and the person that you banged into happens to be carrying a concealed weapon. Imagine you're in a bar. Someone starts a fight. They have a concealed weapon on them. Imagine you're in Times Square visiting with your family. You're on the way to a show with your family, and you're surrounded by people with concealed weapons. Does that make you feel more or less safe? I think we all know the answer to those questions. And again, the numbers don't lie. According to data published 2 days ago by the National Bureau of Economic Research, there's a 29% increase in firearm violent crimes when citizens are given the right to carry handguns. I will repeat that. 29% increase in firearm violent crimes when citizens are given the right to carry handguns. So that brings us here to today. As you know, many of you covered the fact that just a couple weeks ago we signed nation-leading laws into place, the toughest gun laws in America. You have to be older to buy an AR-15, no longer an 18-year-old. We expanded our red flag laws, and we're doing whatever it takes to protect our citizens. But what the Supreme Court did in the Bruen decision is totally, absolutely, 100% out of touch with what New Yorkers want and what they need. So over this last week, I mentioned round the clock, extraordinary team, extraordinary hard work in preparation of an extraordinary session. My team has been working with our partners to craft gun safety legislation. And as a result of our quick work and collaboration with my partners, again, Majority Leader Andre Stewart-Cousins, Speaker Carl Heastie, our state will continue to keep New Yorkers safe from harm, even despite this setback from the Supreme Court. So minutes ago, maybe probably an hour ago now, the Senate passed our proposed bill by a vote of 43 to 20. I've outlined you, a couple days ago, I outlined our conceptual agreements, but we've been fine-tuning through the night, but now that they're about to become law, I want to go through them again. We are creating a definitive list of sensitive locations where individuals will not be able to carry firearms. Common sense: schools, summer camps, libraries, daycares, parks, and playgrounds, places children gather, theaters, museums, entertainment venues, places of worship or with religious observation, polling places, educational institutions, and health and medical facilities, federal, state, local government buildings, homeless and domestic violence shelters, places where alcohol is consumed, restaurants, bars, public transportation, subway, buses, airports, and at public demonstrations and rallies, and in Times Square. We are making no open carry the default position for private businesses. That means that any business, grocery store, retail, private home, place that wants to allow guns on their premises will have to demonstrate that and establish that they put a sign out there that says, concealed carry guns are welcome here. Don't know how many we'll see, but that's exactly, we're going to give them the option, because what we're trying to do is protect the legitimate rights of private property owners by telling them they don't have to have someone walk into their establishment with a concealed weapon, ramping up their anxiety, causing great concern, and they don't deserve that. We are respecting private property owner rights. So we're standing up for their rights, the business owner, the rights of their patrons, the rights of their employees, and the rights of the public. We're also going to be expanding the disqualifying criteria for a permit. For example, if you have a history of dangerous behavior, you shouldn't be able to get a gun. Full stop, period. It's just common sense. We're updating our safe storage laws in anticipation that more people, because of this decision, will be able to be certified to have a concealed carry permit. And that means a lot of guns are transported in cars. Well, guess where the criminals know where guns are and they can steal them. So you have to be able to demonstrate you can lock them up in your car, because a high percentage of stolen guns are taken from stolen cars, as well as in homes. I mean, right now, the majority of, I think it's 67,000 permit owners in the state of New York have their permits limited to residential for their own protection, safety, their families. We are saying that we're changing the law from homes that have children 16 and under are required to store the guns in a safe place to 18-year-olds, again, because we are seeing a real increase in suicides from teenagers, and the accessibility of unlocked up firearms in the home is a point of danger for them, so it's necessary. We're also fixing something. We're updating our definition of body armor to include any form of soft or hard body armor that protects against gunfire, and prohibiting the sale except for those who need it for their profession. And finally, as I've said before, strengthening our gun laws doesn't just mean adding new ones. We went back and looked at our laws because I had a lot of questions about ammunition. Whatever happened to that ammunition database? You know, could there be a background check for ammunition? We're trying to figure out how to make sure we get things right here. And in our review, we determined that there's actually an old MOU that was signed related to ammunition sales after laws were passed a decade ago. It was an administration document between the prior administration and the Senate Republicans, and it blocked the state from taking critical measures to keep ammunition away from criminals. So we are literally tearing it up, and New York will now require and conduct background checks for all ammunition purchases. And we'll also be standing up an ammunition database, so law enforcement can identify and prosecute criminals and compare ammunition records against records of other databases, you know, which identifies people convicted of felonies. You know, we're on top of this. You know, we know this has nothing to do with lawful gun owners, nothing to do with them at all. These are people who have been convicted of felonies or other categories of people that should be prohibited from firearms and ammunition. So I'm directing the state police to move forward and work with our ITS team to move forward in establishing this, and outside consultants, whatever is going to be necessary to get this done. So in conclusion, after all that news, and thank you again for your patience, the Supreme Court's decisions were certainly setbacks, but we view them as only temporary setbacks, because I refuse, as I've said from day one, I refuse to surrender my right as governor to protect New Yorkers from gun violence or any other form of harm. We're not going backwards. They may think they can change our lives with the stroke of a pen, but we have pens too. I give out a lot of pens. And that draws from the office of the governor of the state of New York. And I intend to fully exercise those rights, working with our partners in the legislature to protect our freedoms and to keep New Yorkers safe. So as some of you will have a delayed start to your 4th of July weekend, let us not forget what this holiday means. It's to honor the founding of a great country that cherished the rights of individuals, freedoms, and liberty for all. I am standing here to protect freedom and liberty here in the state of New York, protecting lives, protecting individual freedom of women to make decisions about their own bodies, because this, to me, is the embodiment of what it means to be an American. In honor of our 4th of July weekend, I look forward to signing the legislation as soon as it's finished. Thank you very much, and any questions?
Well, Governor, could you provide examples of how this amendment will protect transgender New Yorkers in particular? And are you worried about any legal challenges over free speech concerns with the gun law in regards to requiring applicants to provide information about their social media accounts?
We believe that we have, let me answer the first question. The amendment prohibits discrimination based on ethnicity, national origins, age, disability, or sex, which includes pregnancy and pregnancy outcomes, sexual orientation, gender identity and expression, and reproductive health care and autonomy. That's on the top of existing protections against discrimination based on race, color, religion, or creed in the Equal Protection Law. So we talk about gender identity and expression in the Equality Amendment. And with respect to the second question, what was the second question?
Yeah, I was just
It's a
wondering
long
if there's
night.
any just like examples of like instances where like transgender New Yorkers could get more like protections, like is it like in the workplace or things like that, or and the second question was about the gun law, if you're worried about legal challenges over free speech issues by requiring applicants for permits to provide information about their social media
Right,
accounts to
again.
assess their character.
I will talk about that first, and Robin, do you want to answer about the transgender? Then,
Sure. So, I mean, the point of this was to make sure that that community was represented and protected. So I think, you know, also the state has done a lot of other work to protect transgender people. So
Okay.
we'll continue to do that.
And we have very strong laws on the books to protect the transgender community, and we'll continue updating them as circumstances change. But you know, we passed GENDA just a few years ago and have some of the toughest laws in our nation to protect their individual rights and freedoms. And with respect to social media, what we are doing here is adapting our ability to protect citizens of the state based on changing circumstances. That's what flexibility means. That's what the ability to adapt means. And with the advent of social media and how we saw a very horrific and chilling example of how the proliferation of hate speech and concepts like white supremacy and replacement theories, how they spread so quickly, like a virus, on social media platforms, really telegraphing someone's content and what they're absorbing and how they're absorbing and what they're saying back. They sometimes are telegraphing their intent to cause harm to others. And we saw that in Buffalo. The evidence was there. The trail was there. And shame on us as a state if we don't learn from those experiences. And as I promised the people in Buffalo, as we buried many of their loved ones, I promised I'd do everything I can to make sure this never happens again. One of those tools now in our toolbox is to be able to examine social media in terms of simply identifying whether or not this is an individual who appears to have been, you know, absorbing this content, perhaps radicalized, and so it's just giving us meaning law enforcement, the tools that they need. Legal counsel, Liz, find anything to add on that?
I think that the Supreme Court made clear that the states have the authority to ensure that responsible and qualified individuals are able to carry weapons, and it doesn't extend to people who are dangerous or mentally unfit, and the social media would be used just to determine whether they're responsible and qualified.
Question for Liz.
We have one.
The Supreme Court case invalidated the proper cause standard, saying it was too subjective. Now, somebody's going to have to judge these social media history and determine that this is, you know, extreme or not extreme. That sounds very subjective now, compared to, say, saying that someone with a felony record or certain misdemeanors can't have a permit. So why do you think this good moral character standard, which was in state law before, can withstand future legal challenges?
Well, first of all, the good moral character standard was not at issue in the Supreme Court. It's used in other states, and if you read the concurring opinion by Justices Kavanaugh and the Chief Justice, they affirmed the ability of states and specifically cited the shall carry states and their regimes for determining qualifications and who's eligible to carry a weapon. And I don't think that there's any question but that the state has the authority and the responsibility to review applicants for licenses to make sure that they are not going to pose a danger to themselves or others if they are able to get a gun. So it's all in furtherance of that. That is the lens through which the licensing agents will review the information that they have on the application. And it's it doesn't infringe any individual right to bear arms, and that's the key criteria in terms of how we approach this legislation.
So you would concede there's some subjectivity that is still permitted under the Supreme Court ruling?
I think we have a very clear set of eligibility criteria here, and we will have our state police and our Department of Criminal Justice Services involved. And if a licensing agent goes rogue, essentially, and exercise their discretion inappropriately, what we have done in this legislation is put in an appeals process at the state level, and I'm hopeful and confident that that appeals process will create a consistency across the state.
Karen?
So regarding the Equal Rights Amendment, what ultimately broke the stalemate? I know that we heard earlier in June it was a language issue and nobody could really explain what the differences were. How did it ultimately come together in the middle of the night?
I'll give you one word: Dobbs. The Dobbs decision. Again, we talked about this in 2018 when we codified the Reproductive Health Act, putting the language of Roe v. Wade into our state law, and all the changes we've made over the years and the countless times I've spoken at rallies, literally over a decade. As the advocates came, we talked about how always in New York we're going to protect these rights. But it was more hypothetical. Those rights were never under attack by the Supreme Court of the United States until that decision. Nothing like a crisis to galvanize people together. That's exactly what happened. So the compromises were had. I said if you can find common agreement between the two houses, I will add this to the subject matter that we are permitting to be discussed, because when a governor calls an extraordinary session, they have the power to set the agenda. At the time, it was simply guns, but I sent the message out there. If you want to get this done in an immediate term, either come back another time or you wait till January, but I think there's an urgency now. So if you can work this out, and we let them work it out. They're very thoughtful. They have their own positions, and they worked it out, and I'm proud of that. That's a real sign that their government works. So I just opened the door, let that happen, create the environment. It's passed, will be passed. Next session, passed again, goes to the voters. So there's a process involved, but that was the inspiration, I guarantee it. Unless there's anything else you want to add to that, Robin? Anything else you saw
No, that
in the
did
dead of the
it.
night? No, okay, thank you. All right.
Governor, what do you say to legal gun owners who have been doing everything right, have gone through federal background checks, state police background checks, and have gone through all the processes to get the guns, that are now feeling like they're a little vilified in the legislation that's being signed into law?
I cannot tell you how many legal gun owners whose rights we will protect are very happy that New York State has background checks. Those are not my words. Those are national surveys of actually NRA members. People support the idea of having common sense criteria to ensure that this does not become the Wild West. So I'll continue to respect their rights. I understand the process very well. It was part of my job as the county clerk. I know about getting 3 neighbors to give an opinion of your character, so there has been subjectivity in other places. I know about the mental health background checks. I know about the state police background checks. I know about all the work that's being done, and so to the legal gun owners, we will protect your legal rights. All right, I know it's been a long day for everybody. Anything else? All right, I don't know if I'll see you again. Go forth, celebrate this great weekend. Despite what the Supreme Court has done. We're here. This is New York. We continue to fight back. Thank you, everybody. Appreciate it.
Governor, one last question. Why did you call the extraordinary session if the legislation was not already ready to be printed? The legislators did not convene for nearly a day after the session began.
We actually gave draft language within days of the Supreme Court decision. We had been working on it. I think I said that earlier. We knew that this case was on the docket. We knew that there was a chance, and as long as there was a chance, I had been meeting with my policy team and my legislative team for weeks and weeks to talk about all the things we wanted to include. We shared our ideas early on so the conversations could start. So literally just having it pass one day after they convened, I don't think, given past history with the budget and all these other circumstances, I don't think that's that late, but that's why we were ready. We gave it to them to start digesting, start their conversations, and everybody focuses. I'm figuring out this is a very nocturnal place. A lot happens late at night, and that's when compromises are made and decisions are made in the legislative side. So I don't think it's a long delay. Literally 24 hours later than we expected. We'll wrap it up today. I think that's extraordinary progress. Thank you.